All right, so this is Jeff Risch, and I'm joined by my partner, Allison Suze. Just a few housekeeping items. All attendees' lines will be muted. We will try to get to questions and answers. There's a Q&A box on the bottom right of your screen. We'll try to get to the questions and answers in the hour. If we don't, and we might not, because of the content, we will certainly get back to anyone with questions after the presentation. We will also be making sure that everyone receives a copy of the slides. We'll email them. Check your spam because it's going to be coming from a generic account here. And so, but you should have them within the next business day. And if for any further information or anything you need to know about our law firm, please check us out at salawus.com. So with that, I'm going to set to begin. I'm going to then turn it over to my partner halfway through, and then she'll take us all home. And get into more concluded, I should say, with some practical to-dos and action items for everyone's consideration. So this change is unique to Illinois. We're talking about Illinois today. Though this trend, we're seeing the trend in New York, we're seeing it in California. There's other states that have regulated convictions more than other states, but Illinois' changes are they're really unique, and I would argue, and Allison can maybe she would disagree with my assessment, but my assessment is I think these are the most burdensome restrictions in the United States, and Allison's going to explain and get into the details as to why. There's a lot of process. There's a lot of movement and actions, right, wrong, or indifferent, with respect to an employer's use of criminal convictions. So, what are we doing here today? What caused us to have this webinar? As most, I believe most of you know, I head up the Employment Law and Litigation Committee for the Illinois Chamber. It's one association of many good associations that I'm familiar with, that I participate in, and certainly our labor and employment group participates in a variety of different employer and trade associations. But what that allowed me to do is see this coming down a while back. So this was on my radar in late 2020 and into 2021. During the lame duck session, I think that's what they call it. The legislature created a bill, part of an omnibus package, a very broad legislative push on a variety of issues. And one of the issues was an amendment to the Illinois Human Rights Act, and it's now part. Everything we're talking today the protections fall under the Illinois Human Rights Act. So the potential liabilities for employers who do not follow this new law and this procedure that comes from this new law and mandate, you would be in violation of the Illinois Human Rights Act and only the Illinois Human Rights Act. So I've been saying it will. Governor Pritzker signed the legislation into law back on March 23rd, 2021. Upon signing it into law, it became law effective immediately. So this is in place. Everything Allison and I are going to discuss here over the next hour is in place today. So if you don't have your house in order, you have a problem. You have a problem. And you need to take a step back, evaluate your processes and procedures, take note of the new mandates, and implement these new mandates immediately. So as of March 23rd, 2021, the Illinois Human Rights Act, it's a violation of the act, a civil rights violation for an employer to use a conviction record as a basis for an adverse employment decision. Anything with respect to hiring, termination, selection for promotion, discipline, anything that would impact the privileges, terms, conditions of employment with an employee or an applicant is now subject to being a civil rights violation. And there are some there's give to this, and we're going to talk about the give and navigating this legal water. The Illinois Department of Human Rights, that's the administrative agency in Illinois that's designed and has been created to investigate and enforce the Illinois Human Rights Act. And the adjudicating body in Illinois is the Illinois Human Rights Commission, which is a separate agency from the Illinois Department of Human Rights. And then, of course, several years ago, the legislator allowed employees and their lawyers to not only take disputes to the Illinois Human Rights Commission for adjudication purposes, but to also file legal actions in state court. So, so as we go through the material, please keep in mind, this is really important, these 5 bullet points. This is not part of Illinois Ban the Box. This is in addition to Illinois Ban the Box law. The prohibition of inquiring into convictions on an application or at any time before a job offer is made or before a candidate is selected for an interview. So this does not involve Ban the Box. This is in addition to Ban the Box. This is also in addition to existing Illinois law on the general prohibition on the use of an arrest record and or sealed or expunged criminal convictions. This law impacts all employers because the Illinois Human Rights Act, again, recent legislation, expanded the protections to protect employees of all employers. So the employers, it used to be if you had less than 15 employees, there were certain things that you could do that would not be illegal, maybe I should phrase it as, if you were a small employer with less than 15 employees, there were things that you could do and it would not be illegal, but it would be illegal if you were 15 plus employees. The law changed recently. All aspects of the Illinois Human Rights Act, including this new criminal conviction prohibition, impacts all employers with 1 or more employees in the state of Illinois. This is entirely separate from, and in addition to, EEOC guidance on arrests and convictions, where we want to make sure that conviction is tied to the position, and the EEOC has their own sets of guidelines and federal cases and decision making and prioritizing their guidance with respect to employers' use of criminal convictions, criminal history. And finally, everything we're talking about is absolutely separate from any and all obligations under the federal Fair Credit Reporting Act. There are specific mandates and requirements that comes from the FCRA with pre-adverse notice and final adverse notice, consumer rights, consumer notices, summary of legal rights for anyone where a criminal conviction record, a criminal record quota would be used against them, including through employment or for employment purposes when the report and the background, the criminal background, is gathered and obtained by a third party. So ban the box, just a quick refresher. There are some limited exceptions with ban the box. This has been around since January of 2015. There are some exceptions that for certain industries and certain position-specific occupations, direct care individuals under and pursuant to the authority of the Illinois Department of Human Services. There are specific, very specific occupational exceptions and specific jobs where if you have a conviction, a certain conviction, not any conviction, a certain conviction, you would be prevented from employment. And so there's some exceptions to that with ban the box. But generally speaking, ban the box is exactly what it refers to, the box on many applications asking whether there's been a crime committed or a conviction of a crime, I should say. Remember, ban the box in Illinois. This is not an Illinois human rights. It applies to employer with 15 or more employees. Chicago and Cook County have their own ordinances that apply to all employers. So just keep that in mind, those nuances. But again, with the Illinois Human Rights Act changes, my general recommendation, and Allison, I don't know what you think, but my general recommendation is, unless there's an occupational industry specific exception that allows you to inquire as to certain convictions in the application prior to an interview, prior to a job offer, I generally say don't ask for it in the application. Remember, okay. I was waiting for you to jump in, Allison.
Yeah, sure. When you're going through job applications, as we do, and you're looking for red flags, the box asking for criminal convictions is always a red flag, and it really makes you ask, is there, a law that's requiring me to ask at this stage, otherwise don't?
The EEOC and just general Illinois law on the use of criminal convictions, the decisions under the Illinois Human Rights Act and even federal case law, we want to make sure that the convictions are job related and consistent with the business necessity. That standard doesn't go away. So it's basically, are we linking the criminal conduct and its dangers with the inherent risk of the duties of the particular position? It's not employer based so much or industry based. It's with this specific position for this particular employer, what are the risks associated with the conviction? And so there has to be some nexus between that conviction and the position sought. And that this analysis just doesn't go away. Now, I can tell you that as we go through the Illinois material here, and we're going to turn to that here momentarily, I'm pretty confident that if we're in line, and this is important, if we are in line and we are doing everything in compliance with the new Illinois law, I'm not really worried about whether or not this is job related and consistent with the Business Necessity Act, because I think I'm covering that by complying with what I perceive to be a much more burdensome standard for employers in Illinois. I think if I'm good with the Illinois standards that Allison and I are going to get with here momentarily, that I'm going to be, I'm going to be confident. I'm not going to ignore the job related and consistent with the business necessity prong, but I'm feeling good. I'm not worried about it because I think the Illinois standard it's much more burdensome and restrictive for the employer. And remember, arrests under Illinois law, it's always been taboo under the Illinois Human Rights Act. I mean, unless you can show and rely on evidence that suggests that the person actually engaged in the conduct that they were arrested for, you can't use an arrest. So you know, I mean, short of, for example, calling a prior employer for a reference check, and then prior employer gives you, which this hardly ever happens, the prior employer will give you a long history of a situation relating to the former employee, and that maybe that former employee was arrested for it, but they provide you facts and details surrounding the arrest. You may not, I mean, that doesn't mean you're going to use the arrest against the applicant. What you're doing is you're using a employer reference, a prior employer's bad or poor reference against the candidate, right? So there are some distinctions between the arrest itself versus circumstances and evidence to suggest that the person actually engaged in the conduct for which they were arrested for. I'm going to use the conduct against them, not the arrest. And maybe it's splitting hairs, but that is a distinction found in the under the Illinois Human Rights Act. But even if I'm going to use that information, does that information still, you know, is it related to the job and consistent with a business necessity? At all times, I'm asking that question. So let's get to the act itself, the amendment to the act itself. Conviction record is what you think it means. It doesn't mean an arrest. It means that the person has been actually convicted. They have been found guilty. They have pled guilty to a criminal offense, whether they were placed on probation, fined, imprisoned, or paroled, doesn't matter. It includes also the conviction under any military authority as well. The employment actions that are prohibited is not just hiring. As I said, any decision affecting terms, privileges, conditions of employment, including promotion and termination. There are, now here's where I think a lot of you listening are really focused on. And there's language in the amendment in the act that says, unless it prefaces the restriction, the prohibition, it prefaces that with the phrase, unless otherwise authorized by law. Unless otherwise authorized by law. Now, we could spend 8 hours debating what the heck that means, because it's not, that phrase is not clearly defined in the act. Surprise, surprise. But the intent behind that, again, back to, you know, my assistance and you know, behind the scenes and my involvement in initiatives, legislative initiatives with the Illinois Chamber specifically. Unless otherwise authorized by law, is intended to clear any confusion over legal mandates, state legal statutory mandates, or federal legal statutory mandates that preclude employment, that preclude someone from holding a specific position due to not any conviction necessarily, but typically specific convictions. So if there is an underlying law that says I can't, not that I'm, you know, not that I'm discouraged from hiring them, not that it's risky if I hire them in a particular position, but if there's a law that says you cannot have X conviction for Y position, then in my opinion, all of this analysis doesn't come into play. It's not triggered. The prohibition would not be triggered. We're going to talk more about that here momentarily. So the unless otherwise authorized by law is there's a lot that goes into that. That's important, and it should not be lost. So those that are in the transportation industry and direct healthcare industry and certain finance industry and banking, that's something you need to keep in mind for specific convictions regulated and commanded by specific law and legal authority on a state or federal level. Now, for most of you listening, and even for those that might have individuals that would fall under that broad, unless otherwise authorized by law exception, if you will, most of you are going to be covered by this broader prohibition that we've discussed. Even with the broader prohibition that you cannot use the conviction against somebody relating to employment, there are two exceptions within that general prohibition. Those two exceptions are as follows: substantial relationship or unreasonable risk. There is either a substantial relationship between one or more of the previous criminal offenses in the employment sought or held, or or the granting or continuation of the employment would involve an unreasonable risk to property or to the safety or welfare of specific individuals or the general public. So those are the two exceptions beyond the unless authorized by law. Following me? That you have. This is the bedrock of this new prohibition. We have to intimately understand the prohibition and what's triggering the prohibition and the exceptions with the general prohibition. So the way I look at it is there's three key phrases: unless authorized by law, substantial relationship, and unreasonable risk. So talking a little bit more about unless authorized by law, various state and federal laws require specific industries, employers, and individuals with certain jobs, seeking certain jobs, or being promoted to a certain position. They just cannot, by law, by operation of law, have a certain conviction. And I can't emphasize this enough. It's usually by occupation and job specific. Some employers think, hey, if I'm in the healthcare industry, I've got, all of my employees would be covered. That's not necessarily so. It's those, typically you're looking at those that have specific convictions for specific positions within that general broader industry. So Illinois, for example, has laws for regulating who can hold certain positions for schools, childcare, healthcare, police, private security guards, and detectives. There's some laws relating to the cannabis industry. The federal government, of course, has laws for FDIC banks and transportation, for example, are the two big ones that come to mind. These laws can restrict employers from hiring anyone with a certain conviction, but again, look at the specific occupations. For example, the Illinois healthcare worker background check, they list 100+ specific criminal convictions that are disqualifying or disqualifying without a waiver. So it's more narrow than some employers think. And it's fool's gold to think that, hey, if I'm in this broad industry, for example, transportation, I don't have to worry about this new state prohibition. That's just not true. It's it's more sophisticated and more narrow than that. So just keep in mind, and if also, even if you are in an industry or specific occupation or position that you think the unless otherwise authorized by law exception applies, keep in mind that if you're using the conviction beyond the scope or limit of that underlying state or federal law or mandate at issue, if you're using it beyond the scope or limit of that law, the IHRA amendment will control. And you're back to relying on either the substantial relationship or the unreasonable risk analysis. The transportation industry, for example, this is a good example, kind of putting that under the microscope to further try to explain what I'm getting at. That requires the FMCSA, Federal Motor Carrier Safety Administration, requires that the transportation industry conducts criminal background checks, obtain driving abstracts and driving conviction records to qualify drivers during hiring or the retention process. So there are specific criminal offenses outlined with the underlying federal motor carrier safety regulations, and so it's more narrow, right? It's qualifying drivers for a specific position of driving, operating that vehicle, and on the backdrop of specific narrow offenses that are outlined in those regulations. So if the otherwise authorized by law would fit, so long as we're dealing with that limit. Even though I'm in the transportation industry, I've got various individuals within the transportation industry. I've got sales, I've got office administration, I have other people. That doesn't in many positions. So this federal mandate that precludes drivers with certain convictions from driving, that's a pretty narrow scope of that of that federal mandate. So there's a lot of triggers here that the transportation industry employer is going to invite that would create create obligations, and they would find themselves having to navigate this new prohibition with respect to other positions outside of driving. Substantial relationship, the second key term. To be really honest here, Allison, I think this is impossible. I mean, it's maybe nothing's impossible, right, Allison? But this requires, you can see it in red right in front of you, right? Will recur. If you rely on substantial relationship to deny employment or to take adverse action against an employee due to a conviction, substantial relationship means that first you need to consider whether the employment position, the job, offers the opportunity for the same or similar offense to occur, and whether the circumstances that led to the conduct for which the person was convicted will recur in the employment position. Not may recur, not could recur, will. I don't know. I mean, you tell me. I read that as a lawyer. I read that as a layperson, as a lawyer, as a business owner, and I'm thinking to myself, how do I even get my arms around this exception? And with the exception, yeah, Allison?
Well, I'll jump in to say it is a super high standard, the will recur language. makes it pretty hard to meet. And I think one of the things that's confusing about this language is they list these 6 factors to look to, but those all go to the description and the circumstances of the conviction. But you need to look not only at the conviction, but the position that the person is either applying for or in. And that's where you're looking at offers the opportunity. So you're not only looking at the 6 factors of the conviction, how severe it was, how recent it was, the circumstances, but also with that person and that criminal background, what are they doing in your position? Who are they by? Who are they exposed to? What are their job duties? And linking them together. So it's a very sophisticated analysis to meet that standard.
Yeah, and I've seen substantial relationship used. I believe I'm speaking a little out of turn here, but I thought New York had something like this, but they define substantial relationship much differently. So, just word to the wise, everybody, you look at these other states and, this trend of criminal convictions, even Wisconsin up north, they're using terms of art with respect to convictions and regulating convictions. And that's, that's sort of the new trend. These definitions will vary greatly from state to state. So when I look at substantial relationship in Illinois, this definition is absolutely, at least as of today, April 29th, 2021, is really unique to Illinois. It's a unique definition. And as you get your head around it and you think about it, this is something that, I'm not comfortable with. I'm just not comfortable with navigating people through that type of that standard. Now, unreasonable risk, that's the other exception to the general prohibition. And the unreasonable risk is much easier for me to understand and comprehend and navigate businesses and employers through it, because while it's not defined in the Illinois Human Rights Act, I think it likely is going to be reviewed under some objective reasonableness standard. And again, the same 6 factors that you would need to consider as an employer to come to the conclusion that if I bring this person on or if I promote them to a certain position, there is an inherent objective unreasonable risk to property or to the safety of others due to the conviction. And so with that, Allison, I'll turn it over to you and why don't you go forward with the interactive assessment?
Thanks, Jeff. So this interactive assessment, I think, is part of the reason that Jeff is saying this Illinois amendment is so burdensome on employers, because not only is the amendment telling you what you can and cannot consider, it's also telling you how you can go about considering it and how you can make these decisions to take an adverse employment action based on conviction history. And it requires a fair amount of administration and effort on the employer's part to make sure that you're following each step. So the amendment envisions an interactive assessment similar to the Fair Credit Reporting Act interactive assessment, where you're going to reach out to the employee 2 different times before you take an adverse employment action based on their conviction history. The first is you're going to provide a preliminary decision, which says we are thinking about taking an adverse employment action, whether it's not hiring you, terminating you, denying you tenure, whatever you're taking, you reach out. It needs to be in writing. And you let them know that you're thinking about taking this action, and you provide them with an opportunity to respond, show that either the conviction was inaccurate, which is tough for an employer to have to be guessing a conviction, or that there has been enough mitigating circumstances or rehabilitation that that conviction should not be disqualifying. Keep in mind it needs to be in writing, and we'll go a little bit more on the next slide into what the preliminary decision communication needs to say. Preliminary notification is going to identify the specific conviction you're considering. An individual might have a whole host of convictions in their history, and some meet the exception that you're looking at, create an unreasonable risk or a substantial relationship, although as Jeff mentioned, that's pretty hard to show, and other convictions are irrelevant. You want to pinpoint the specific conviction, the date, and the nature of the conviction that you're looking at, and tell them that you are not hiring them or you're taking an adverse employment action because of this specific conviction or convictions, and provide a copy of the conviction history report if you have it. So the applicant or the employee knows exactly what they need to defend against, or knows at least exactly the reason for the preliminary decision. The other thing that you need to provide is the employer's reasoning for the disqualification, and you want to strike a delicate balance of providing enough information to show that you are genuinely trying to comply with the amendment, with the Illinois Human Rights Act, and not providing so much information that you stick your foot in your mouth or later on, find that you said too much, because anything you put in these letters is going to follow you if a charge of discrimination is filed or if there's any sort of litigation. So I think the best way to strike this balance is provide enough information to show that you really went through the entire law. You did the entire analysis. So say which exception you're using. Do you believe that the conviction is disqualifying because of an unreasonable risk, or are you using the substantial relationship to the position exception? Those buzzwords are going to help you. Then even go back and use those factors that the amendment provides us with. Is it the severity of the conviction? Is it the recentness of the conviction, the circumstances of the conviction? And as long as you're drawing back from language from the amendment, that's going to help you to show, if you ever need to defend this decision to the IDHR or to a court, that you are following the law. The last thing that's really important is your preliminary notice wants to allow employees the opportunity to respond to the notification. They get 5 days to do that. And they can respond and say, no, my conviction should not be disqualifying, either by presenting evidence that challenges the accuracy of the conviction or provides evidence in mitigation, such as rehabilitation. Now, a question is, some employees or applicants are not going to respond to this preliminary notice. You still go through each step of the interactive assessment, but of course, some are going to respond. What would be things that an employer and applicant can send to you that you need to be considering as a mitigating factor that would make this conviction not disqualifying? So I just wanted to provide a couple examples of evidence of rehabilitation that you're going to want to document and show that you considered if they present it to you. It could be proof of volunteer work, proof of schooling after the conviction, receiving job training, letters from parole officers or certificates of good behavior showing that they're complying with their parole terms, negative drug tests, counseling or social services programs. Maybe they received professional help for drug addiction, anger management, anything that is showing that this employer applicant has made good use of their time since being done serving time for their conviction, that they've been productive and successful. I think a huge piece of evidence of rehabilitation would be proof of subsequent employment for a long period of time, especially if it's in the same industry, with references showing that there's been no subsequent problems. They've been successful employees in that field.
Yeah, Allison, I think that's in my experience, I think that's the best evidence.
Right. The proof would be in the pudding, right? You know that they can work in that job and that there hasn't been future problems. I don't even know how to get into if they're going to challenge the accuracy of their conviction. There would have to be pretty compelling proof that the conviction was inaccurate for me as an employer to not be able to believe a jury or a trier of law on the conviction. I will say it could come up that they might reach out and say, my conviction is in the process of being sealed or impounded. Those proceedings take months and months, so it's conceivable that at the time you did the background check, it hadn't been sealed, and then at the time you're making the preliminary decision, it has been sealed. That would be something to consider, and under the Illinois Human Rights Act, employers are not allowed to consider sealed convictions. So that, that could be an example of something that an employee presents to you that would be pretty compelling. Keep in mind that if they were able to get their conviction sealed, they would need to show the same sort of rehabilitating factors that you would be considering anyways. There would be a length of time where they were successful and productive members of society, things like that. So once you've considered all the information that the employee sends you, and even if the employee does not send you any information or applicant, you're going to send out a second document as part of this interactive formal assessment. The final decision notice is pretty similar to the preliminary notice decision. You're going to send out again the specific conviction that you're considering. You're going to document either that you didn't receive a response from the employee, or document that you did receive a response and it was not convincing, and that you're going to stick with your preliminary decision. And before, you're still going to say the exception that you're relying on, whether it's the substantial relationship or the unreasonable risk, and go back to those factors. If you didn't find that there was enough evidence of mitigation, go back to the factors that you considered in finding that the conviction was disqualifying. Importantly, this final notice needs to have two other pieces of information in it that are different than the first preliminary notice. You need to provide information on any existing procedure that you have for them to challenge the decision internally. I suggest making this clear, bold font if you want, make it really easy for the employee to exercise this route, because the alternative is that if they feel that they want to challenge this, the alternative is you also need to provide information on how they could file a charge with the Illinois Department of Human Rights. Of course, you'd always rather field these things internally and see if they can be resolved, or at least be on notice that this is going to, become something. So to the extent that you can encourage them to bring the complaint internally, I would provide a specific contact person, specific contact information. Just make it easy for them to complain internally before they file a charge.
Yeah, and Allison, just something else to note: if employers sometimes have a like an internal catch-all grievance procedure or policy, or even a contractual obligation. So, I think that prong of the procedure, that may already exist for some employers that have adopted this catch-all, that would apply for existing employees, not necessarily applicants or candidates, but maybe existing employees. So employers just need to keep that in mind as they're evaluating that specific requirement.
Yep, and I mean, any way that you can field it internally first is best. And it's probably a little bit scary for employers to have to send out communication to people that they're taking adverse actions against, and actually provide information on how to file a charge at the department. So it helps to try and, I guess, beat them to it and say, well, complain internally first. The next question is, if you are disqualifying applicants because of criminal convictions, or taking any adverse action because of criminal convictions based on those state or federal laws that Jeff was mentioning earlier in this presentation, where a law is actually requiring you not to employ somebody with certain convictions in certain positions, do you need to engage in this interactive assessment under the Illinois Human Rights Act? Jeff and I have parsed through the statute and debated this, and it's not explicitly said in the statute that you don't need to send the preliminary notice and the final decision notice in cases where a law is prohibiting you from hiring or employing somebody with a certain criminal conviction. But if you read the whole amendment together, it's pretty fair to assume that you do not need to engage in the interactive process in those situations. When they talk about doing the interactive assessment, they say only after considering mitigating factors in subsection B do you then need to engage in an interactive assessment. Well, earlier in the statute, it says unless authorized by law, you need to consider these mitigating factors. So when read all together, it's fair to assume that you don't need to send out those notices and final decision letters if there is a clear law telling you that you're not allowed to hire or employ that person. And as Jeff mentioned before, if you're going beyond what the law is saying, if they list convictions A, B, and C, but you're considering conviction D, and it's outside of the narrow scope of the law, then you're right back within the field of the Illinois Human Rights Act, and you do engage in the interactive assessment. this slide is mostly just for employers to take a deep breath and relax just a little bit. Of course, this amendment is opening up employers to charges of discrimination, potential liability for their hiring and employment decisions, and also creating a lot of administrative steps that they have to take when they make these decisions through the interactive process. But the amendment doesn't go so far as to undermine the main reasons that employers are pursuing these criminal background checks and being worried about hiring people with certain convictions in the first place. So I just want to go through these really quick to remind and reassure employers that even though there are new prohibitions on considering criminal conviction, it doesn't stretch so far as to erase the reason that we're doing these criminal background checks in the first place. The first reason that employers are likely wanting to do criminal background checks is, of course, there's a huge concern with combating theft and fraud in the workplace and also preventing workplace violence in the workplace. But if you can show that somebody that you're hiring would create a substantial risk of theft or fraud in the workplace or workplace violence, then they fall within the exceptions and you don't need to hire them or have them in your workplace. So it's just a way that the amendment is, I guess, addressing that employer concern. The next one, compliance with state or federal laws. Again, the unless otherwise authorized by law ensures that employers can always follow whatever laws are prohibiting them from hiring certain people with criminal convictions without running into the amendment or creating any sort of liability. Preventing use, possession, or distribution of illegal drugs is obviously a huge concern of employers. You want to make sure that you have a drug-free workplace. If, again, somebody has a history of criminal convictions where there's a substantial risk that there may be drug distribution in the workplace, for example, you would be able to show that that can't be disqualified under the Act. And hiring anybody brings risk. It's just really assessing who has a high enough risk that it would be unreasonable to bring them on board. And the amendments cater to that situation and understand that. The last one is probably when you hear that you're not allowed to consider criminal convictions, employers are wondering, well, am I between a rock and a hard place now? Because I'm not allowed to not hire somebody because of a criminal conviction, but if that person then goes and commits a crime against a coworker or a third party, am I now on the hook for a negligent hiring or retention claim? And the answer is probably not. Again, the exceptions accommodate the risk of a negligent hiring or retention claim, because in order to be liable for negligent hiring, for example, you would need to show that you could see a foreseeable risk to coworkers or third parties and you ignored it, or you should have known about a foreseeable risk and you ignored it and then harm followed in that foreseeable way. But if you can see a foreseeable risk based on somebody's criminal conviction, again, the Illinois Human Rights Amendment exceptions would apply. It's important to know that negligent hiring and retention claims do exist in Illinois. There's no blanket civil immunity for employers. And I think it's important to think about these negligence claims in that if employers are looking at this Illinois Human Rights Act amendment and thinking, you know what, I'm just not going to do any criminal background checks anymore. I used to think they were important, but I don't want to do them anymore because of the headache of the interactive assessment and whether I can or cannot consider it. Keep in mind that one of the things that courts look at in these negligent hiring claims is, should you have known about this foreseeable risk? And there have been cases in Illinois where somebody was hired, committed some sort of crime against a coworker. I can think of one that was heinous. It was a violent crime against a coworker, and they had never done a background check to see that this person had similar convictions in their past. And they said, that's enough. You should have known that this person created a foreseeable risk. So I wouldn't completely stop doing criminal background checks if you were previously and you thought it was necessary to do.
I think, yeah, I mean, Allison, this law does not preclude the processing and employers obtaining a criminal. It's the use of it and navigating the very narrow and the narrow exceptions and the formal process that's now in place. So if you ask me, Allison, if should we scrap it or shouldn't we, I would tend to say, I think in today's age and times, if you're scrapping it, buyer beware, and it could really come back and and create liabilities that far surpass anything that would be created under the Illinois Human Rights Act. So that's just my 2 cents.
No, I agree, because at least you know, and with the exceptions, you can take action if they fit within the exceptions, but you at least you know. You would like to know when you're hiring somebody, especially in certain industries where they're interacting with students, elderly, you know, driving, whatever it is, at least then you know. This is just to go into the Fair Credit Reporting Act reminder. This is in addition to what we've covered. Send your notices out separately. Don't combine them as one. And we're running a little bit short on time, but just to give a real quick summation of this law, if you're going to use a third-party screening company to obtain information, just make sure that you are giving the applicant notice, getting their written permission to use it, certifying to the company that you have followed the law, that you provided the notice, that you got the permission. And if you're ever going to take an adverse action based on information received from that third-party screening company, provide a copy of their rights provided under the Act and a copy of the consumer report. And then, of course, after you take the adverse action, give notice that the adverse action was taken. These are just, in the wake of this amendment, what are the best steps that employers can take to make sure that they are being as proactive as possible to limit liability from this amendment and to streamline their hiring practices as it relates to criminal convictions. These are a couple of disclaimers that are great to use in the application process. Conviction will not automatically exclude you from consideration for employment opportunities. That's, you know, straight from the amendment. We're no longer allowed just to blanket say we will not hire people with criminal convictions. So put it in your application, show that you're complying with the law. Another great disclaimer to use is, under no circumstances should you disclose an arrest that did not result in conviction or a conviction that has been ordered expunged, sealed, or impounded. And that's just going back to language in the Illinois Human Rights Act that was present even before this amendment, that employers are not allowed to consider those items. Another useful disclaimer is that the employee or the applicant would certify the facts and information that they're providing as to whether they, as to their criminal history. Because remember, it is one thing to take an adverse action against somebody because of their criminal conviction, and it's quite another that's not covered under the Illinois Human Rights Act to take an adverse action based on dishonesty or lying in an application or lying to your employer. So if you have this sort of disclaimer in there, it is helpful. What to do moving forward, make sure that you review and, if necessary, modify your job applications and hiring policies by using those disclaimers, taking out any language you have that you automatically disqualify applicants based on any criminal conviction or certain criminal convictions. And it's important to train your managers and supervisors on how they are both handling fielding information on criminal convictions to make sure you're complying with ban the box, this new amendment, and then also how they're analyzing these exceptions, because Jeff referenced the EEOC guidance, and there still is a lurking issue out there with disparate impact claims. The EEOC is so concerned about that, and disparate treatment based on criminal convictions. Of course, minorities have higher rates of criminal convictions than white employees or applicants. And you just want to make sure that if you are undergoing this analysis and saying, we are not going to hire this candidate because of this conviction for this position, we think it's an unreasonable risk, you don't have a candidate in a different protected class that you analyze differently. So consistency is key. Revise your policy, use strong language that is in line with the language of the Illinois Human Rights Act. Evaluate your positions, this is important, at your company, and decide which ones do you need background checks for. Is it job related and consistent with business necessity? And this again goes back to the EEOC's concern and potential Title VII claims on disparate impact. Because if you're going to conduct a criminal background check, you're probably going to find that applicants of certain races have higher rates of conviction. And if you're going to disqualify those, just make sure you can justify it and say it's job related and consistent with business necessity, so you don't have a disparate impact claim. Review and update your conviction inquiry forms. while you're going through all of your different hiring notices and preliminary notices and final notices, look through how you're handling the FCRA, create model notices. Jeff and I have worked on model notices for the preliminary decision and the final decision for the interactive assessment. If you have shells that you're using and plugging in information specific to your case-by-case analysis for each applicant, that will just help with consistency. And then think long and hard, as Jeff mentioned before, about using the substantial relationship exception because it is such a high status.
Yeah, I'm simple-minded, Allison. I just think it's too cumbersome. It's just because, you know, as I think about it, Allison, unreasonable risk. And I looked quickly at New York. New York has a direct relationship definition. Again, very unique to New York. Wisconsin has substantial relationship, totally unique to Wisconsin. But I look at the definition of substantial relationship that is actually expressed in the statute, right? And I just shake my head. Like, I just don't know how we would even begin to navigate through that. I guess facts will dictate, but unreasonable risk, that seems with property and people, that to me seems to be the logical, sensible, reasonable exception that's going to play. And probably going back to trying to, you know, knock off your compliance with federal mandates and other mandates, that will play nicely into, you know, the business necessity. You know, I feel that, and you can disagree, Allison. I just feel that if we're complying with the Illinois mandates, then I feel confident of how we are with other mandates, specifically Title VII, amongst others. But
I agree with you. I think the substantial relationship, because it is such a tricky standard, probably right now, before we see how it's analyzed, and as time goes on, we'll see that better, might be applied to more, I guess, unique situations. Let's say somebody had a white collar felony that related to data fraud and they had a data entry position or something where you can link the position and it completely overlaps with their conviction. That might be where that exception would come more into play. But the unreasonable risk one is easier to apply for sure.
Yes, the facts will probably dictate, but well, you know, Allison, you mentioned it. We put out these forms in a guidance as well that summarizes this presentation. And I think it's on our Labor and Employment Law Update blog. So everyone, you know, if you want those forms, if you want more guidance to share internally, of course, we're going to be sending the PowerPoint to everyone in the next business day or two. But go to our blog and you'll be able to find it. It was recent, and I think you'll find it helpful. Any other, you know, as far as questions and answers, I think it'd probably be best to just reserve it and we'll answer it on an individual by individual basis. That'd probably be easier and more efficient use of our time. Any parting words of wisdom, Allison?
No, just thank you so much for your time. And I think it's great to be listening to webinars like this so you can proactively take steps to address this amendment, because as Jeff said, it's effective right now.
All right, well, thanks everybody. Appreciate you attending. If we can be of any further assistance, just reach out.